Thank you. I appreciate it. Thank you very, very much. I really appreciate it, and I'm just thankful to be here. I really am. And the presentation, I'll admit, there's a lot of information in it. It is long, but I will go through it very quickly. I'll go through it as quickly as I can, because what I've done is basically, there's a lot of important history that's been left out about our Constitution, obviously, over the years, and especially Article 5. And so what I tried to do from the resources that I dug into, I tried to bring some of that out, especially from the founders themselves, what they said about Article 5. So what I'm going to do is try and recap as fast as possible, as much as possible, about the history of Article 5, how it came to be, and the conventions that took place leading up to our Constitutional Convention. So having that knowledge will help us have a little bit more of a comfort factor with Article 5 and what we're looking to do. So without further ado, again, it's a lot of information, but I will go through it as quickly as I can. Again, my next higher up is Jenny Rapini, who has been extremely supportive. I'm just so thankful to have her. And then myself, you've got my email here, and my coalitions director, who is at another meeting tonight. We double booked, so he's at another meeting, is Stuart Dodge. But if you ever have any questions or would like to contact him, we are also looking to link up with different organizations to get their support. So he's the coalitions director. And then I'd like to mention Deborah Stevenson. She's with the Elk Grove Tea Party, and she is like my right hand. She helped me follow up, and there's so much to do as a state director, and so she has helped me immensely. What I'm going to cover tonight is as follows. I'll cover some of the references that I use, that I've been digging into and using as my resources for information. We'll talk about the problem. Obviously, we know that's Washington, D.C. The solution is Article 5. I'm going to go back. Before we go into Article 5 too deep, I want to step back in time and take a look at, there's 3 waves of historical writings about Article 5. And it's important to understand what was written about Article 5 in those 3 different periods and what came out of them. And then we're going to go back even further, and we're going to cover very quickly the history of multi-state and colonial conventions that took place in the century leading up to the Constitutional Convention of 1787. Then I'll talk about Article 5's adoption, basically the history and the reasoning for its adoption or inclusion in the Constitution. We'll talk about the Article 5 process, the roles and authorities, and then finally I'll go back to the founders themselves, and we'll take a look at what they said about Article 5, because to me that's what matters. I don't want you to believe what I have to say. I want you to do your homework and know what they had to say, because that's what's important. And then we'll cover very quickly the conclusions of the 3rd wave of Article 5 writings. That's the most recent body of evidence that's been researched about Article 5. And then we'll cover very quickly the checks that are out there for a potential runaway amendment or convention. And it's really more of a myth, but we'll cover those checks. And then we'll cover the Convention of States strategy that we have for the convention, and some potential amendments that are out there. And then I'll cover the current status of Convention of States as it stands today. And then we'll go into a Q&A session. So I'm going to go through this as quickly as I can, so that hopefully it gives you as much information up front. And then we'll go into Q&A, and I'll do my best to address any concerns. With that, and then I'll wrap up with how you can help if anyone's interested. First of all, the references that I use, obviously Article 5 of the Constitution. The Convention of States Project Handbook can be found on the website. It's about 21, 22 pages, and it's it's an excellent executive summary. And then we have the Convention of States Project Compendium, and that's for lawyers and legislative drafters. This is about a 340-page document that was drafted by Professor Nadelson, who is one of the preeminent scholars on Article 5 in the United States. And then, of course, the founding era conventions and the meeting of the Constitution's Convention for Proposing Amendments. That document is also contained in the compendium, and it's by Professor Nadelson. And then finally, I took some of the ideas for potential amendments from Mark Levin's book, The Liberty Amendments. Very quickly, I don't really usually talk about this very much because we all know what the problem is. Washington, D.C. is broken. We don't have to go through it. We don't need to, I don't need to lecture you on what the real problem is because we know what that is. We have a spending and debt crisis. We have 17 to 18 trillion that they're telling us about in debt. We have a regulatory crisis that's out of control, congressional attacks on state sovereignty, and basically a federal takeover of our decision-making process all the way down to the state level, county and city levels. I know here in California, being in Fresno for 12 years, being involved in local politics, they hardly had any discretionary spending at the county level. They were spending, getting to spend maybe 20 cents on every dollar. The rest of it was obligated by federal strings that were attached. So we all know that problem. What does this mean? It boils down to this. This is not a conservative issue. It's not a liberal issue. It's not a Democrat or Republican issue. It is an American problem. Every one of us as American citizens needs to be concerned about this because it's not a partisan issue anymore. It never has been, but it's not a partisan issue, what we're trying to do. The state legislatures, they're completely losing their constitutional authorities, and they're basically being usurped by the federal government. We know that Washington will never relinquish that power. They predicted that at the Constitutional Convention, if this ever happened. They knew that they would not do it. And so it means that our state legislators, and we as citizens must get active. We must get involved, and we got to be serious about it. We don't have a lot of time left, to be quite honest. But we do have the power. We, the people, hold the final say. And so if we use that power, we can make it happen. The solution, Article 5 of the Constitution. It provides two methods by which to propose amendments to the Constitution and one method to ratify the states. Here is Article 5 itself, and I'll just very briefly say that we're focused on the second option. Obviously, the first option, Congress can propose their own amendments, and it takes 2/3 of both houses to propose an amendment, and then those amendments that they propose have to go out to the states for ratification by 3/4 of the states, or 38 states. The second option is what we are focused on, is getting 2/3 of the states, 34 states, to apply under the same exact topic, the same operative language for a convention of the states to rein in the power of the federal government. And that's what we're looking at. The Congress, I'm only going to read the second option because that pertains to the states. The Congress, on application of the legislatures of 2/3 of the several states, shall call a convention. So that's what we're focused on. But before I go any further into Article 5 and interpreting and things like that, I want to take a look at the historical writings about Article 5, the three different waves. The first wave of writings about Article 5, and this is more or less what I learned when I was a kid, was out of the 60s and 70s. Most of this writing was done by authors primarily that were university academics. A lot of them, quite frankly, had an agenda, and it was opposed to any kind of convention being held. The sources that they used were small amounts of information from the Constitutional Convention, but there was never any mention whatsoever about any prior convention before 1787. They completely left any historical records of any prior conventions out of the picture. And so basically it was very speculative, and the message that they gave was, it's a Pandora's box. It could be a con-con. We don't know what could happen because you have no idea how these conventions, could be run. It was as if this was the only convention that was ever held in this country, is the way it was written. So that's the first wave. The second wave was more of a transitional body of work. It improved on the sources that they used. They increased the number of sources. They included the Constitutional Convention debates, the ratification records, and some court opinions. But it still only left some brief references to any kind of conventions that took place prior to the Constitutional Convention. So it wasn't quite enough to make any of the scholars comfortable enough to conclude that. And they did recognize that there were limited subject conventions that did take place, but it just wasn't quite enough for any of them to conclude that they were comfortable with an Article 5 convention yet. So fast forward now, 2010 to the present, they have fully reconstructed the historical records on 31 conventions that took place in the century leading up to 1787. So we now have a much larger picture of exactly what happened. There were 31 conventions leading up to the Constitutional Convention, and it really told us a lot more about how they were run. They were widely accepted, and so we just have a much better picture. So this body of evidence now gave us just a better picture of the convention history and practice, and it gave us a much clearer understanding of how an Article 5 convention would run, because Article 5 was based on those conventions. And we'll see that in a few minutes. So now we're going to go back up even further and actually look at the real history of the conventions that took place before the birth of the Constitution and Article 5. We have approximately 20-some conventions that were prior to 1776. And then from 1776, you had another 11 multi-state, what I call multi-state conventions that led up to the 1787 Constitutional Convention. And it's important to understand these types of conventions were widely used by Englishmen and Americans several generations leading up to the Constitutional Convention. They were well established, they were widely accepted, and they were well understood as far as their rules and procedures. And then finally, all of them, the vast majority of them, were in fact limited in their scope of subject matter, their discussion, because they were there to discuss and solve prescribed problems. That's all they were there to do, was solve a specific problem. So it's important to understand this. And these are just some examples of about 5 or 6 conventions that took place between the 1750s and 1779. I've been reading about some of these. I'm not as well versed and comfortable with them, but I've been reading about them, and it's fascinating. It's just very enlightening, and it's very encouraging to find out more about these conventions. And the great question is, what did they discuss? Well, these are some great examples of exactly what they discussed in those limited conventions. They discussed things as Indian affairs, defense, inflation, trade, price controls, and wouldn't you know it, at the bottom, I thought there was one that was very interesting that might appeal to us. They dealt with addressing ineffective regional governors and governing bodies. So this is not the first time that a convention has dealt with an ineffective government. So it's good to know. Next, I like to try and cover as an example, because some of the stuff that has been lost in the past was terminology and a good understanding of historical terminology and what the founders were talking about when they talked about conventions. And this terminology I brought out of the legislator's compendium for a specific reason. And I want to discuss the types of conventions that are out there, because there's one of these terms I want to bring up. First of all, the in-state versus a multi-state convention. This deals with the participants in a convention. An in-state convention would mean like a ratifying convention, because a ratifying convention, after the convention of states takes place, for example, a ratifying convention is a mode of ratification that could be used, and each state would have their own in-state convention to ratify those amendments. So, and it wouldn't include any other state. So an in-state convention is just that. Participants are from within the state. And then a multi-state convention, obviously you're inviting a number of states to participate because it's a regional or a nationwide issue. And then here, the second category is a general versus a partial convention. The second category of conventions was a general versus a partial convention. And this had to do with geography. A general convention meant that all states or colonies were invited to that convention, versus a partial convention might be a regional convention because there was only an issue that certain states or colonies needed to address. And this is where I really want to highlight it, is that you've heard in the past about some opponents of a convention of states talk about, well, you don't know what's going to happen, because when they talk about a general convention, it could be, it's basically, they talked about it as if a general convention was wide open as far as the subject matter, and that was simply wrong. A general convention in the early historical writings was basically mislabeled as something that they could take on any topic, and it could basically be a constitutional convention is what they were hinting at. But the bottom line is, when the founders talked about holding a general convention, they were talking about a convention that included all states or all of the colonies. It was the participants. It was not, or geography. It did not relate to the subject matter. When it comes to the subject matter of what they can discuss at a convention, that had to do with the bottom category. There's a plenipotentiary convention, which is wide open in as far as subject matter, or you can have a limited convention, and that's a limited subject matter. And then obviously you have the proposing versus a ratifying convention. There were very, very few conventions out there that existed that were authorized to do, that were authorized to both propose and ratify in the same convention. And in Article 5, we have two different conventions. One can only propose, and the other can only ratify. And this is just some more terminology I just cover. The application or the call is basically what is passed by each state legislature. Each state has to pass their application and pass it on to Congress in order to, result in a convention call. The convention call itself, in our case, once 34 states pass an application and transmit it to Congress, Congress would make the congressional call, and they would name the time and the place, and that is about it. The commissioners are the delegates that are elected or selected by the state legislatures. It is completely up to the states as to how they're going to select their delegates. And the commission are documents that are used, kind of like when I became an officer in the military. You've got an order that basically commissions you. You're commissioned by the President of the United States. So there's commissioning documents that are used to basically formally sanction those people as participants in the convention. And then the legislatures also have options of issuing additional instructions that they can limit what their commissioners can do at a convention. So those are important to understand. And we'll talk about those a little bit later. Next, Article 5's adoption. This is really important to understand is why Article 5 came to be. After this, this century of leading up to the Constitutional Convention, they had some pretty good experience with conventions, obviously. So we now know that, and it's easier for us to understand now. When they were at the convention 2 days prior to the conclusion of it, George Mason realized that the first draft of Article 5 only allowed Congress to be the only authority to propose amendments to the Constitution. And they said, wait a minute, are we so naive to think that a federal government that gets out of control is going to put itself in check? No way. We know that's not going to happen. So it was unanimously approved to add the second mode of proposal to allow the states to call their own convention. So it was unanimously approved, and it was specifically intended and written so that the states could bypass Congress, go around them, because they would have nothing to do with the state convention. And so it was unanimously approved, and in fact, I didn't know this, but ratification of our Constitution hinged, in addition to the Bill of Rights, it hinged upon Article 5's inclusion. So that was very important. It was to give the people and the states the right to amend their own Constitution if Congress got out of control. Finally, the process. Here's, in brief, the process, a good graphic, hopefully. The states, 2/3 of the states, pass applications, and it's important to understand this is not an easy process. This is not a simple process. Both houses in every state of 34 states, that's basically 68 houses, have to pass the application in order for it to go forward to Congress. Once both houses in 34 states pass the application, they're transmitted to Congress. Congress will count all the applications. They will aggregate them and make sure that they are legally all the same, because the operative language must be identical in each application for them to qualify for that convention. And then finally, next, the Convention of States takes place. Congress basically is in and this is something I should mention, I should just pass over it. Congress's role is extremely limited here, because under Article 5, it's like agency law. Congress and the states, under Article 5, basically shed their legislative roles and responsibilities, and they are only acting under the agency of Article 5, and they are only acting under the authority that is given to them by Article 5. They can do nothing more than Article 5 allows them to do. And so Congress's role is simply to count, to aggregate the applications, make sure that they're all the same, and then they call the convention, and that is naming the time and the place. And the only other administrative role that Congress is allowed under Article 5 is that they may select or propose which ratification mode may be used. They can delegate that they will either ratify via in-state convention or the state legislatures will vote upon it. So they can basically tell them what ratification mode that they will use. But outside of those roles, that is all that Congress has. That's all they can do. And then finally, I skipped forward, and I don't know how to reverse on this, but the final step obviously is ratification. And of course, ratification will take place in the states, and that will either take place by the state legislatures or in state conventions within each state, and Congress will select that mode. And again, I just covered this actually. These are Congress's roles. That's all they have, really. And finally, a big question, and I try to address this as best I can. None of us know exactly what they will use, but the question is, okay, what will happen at the convention and how will they run the convention? Well, that's going to be up to the convention delegates. But I can tell you this, based on my research, and most of it's based upon Professor Nadelson's research and his writings. There's a document out there, and it was written by a California legislator named Paul Mason. Mason's rules is used throughout the United States in the vast majority of state legislatures. So Mason's rules, as something he has mentioned, is very likely a procedural book that they will likely use for such a convention. This book was written by Paul Mason. He was a California legislator, and it covers everything, from motions to tabling. I mean, you name it. It covers everything. So the bottom line is we don't know exactly what's going to happen at that convention, but the delegates who are appointed by their states are going to have control of that convention. Congress will not have a role at the convention. Neither will any governor have a role in the convention unless they're allowed by their state legislatures, because this is the only two parties under Article 5 given any authority is Congress and the state legislatures. No governors unless they give it to them. And this is what I really like to cover, because I don't want you to take my word for any of this. I want to cover what some of the founders themselves said and what they had to say about Article 5, because these quotes are just very enlightening. George Mason, the man who came up with the second option to allow the states, or to ensure that the states had the ability to bypass Congress, said this: "Amendments, therefore, will be necessary because they knew that the Constitution was not going to be perfect. They didn't count it as a sanctimonious document. They knew it might have trouble down the road. Amendments, therefore, will be necessary, and it will be better to provide for them in an easy, regular, and constitutional way than to trust to chance and to violence. It would be improper to require the consent of the national legislature, Congress, because they may abuse their power and refuse their consent on that very account." He said that no amendments of the proper kind would ever be obtained by the people if the government should become oppressive. James Madison stated that should the provisions of the Constitution as here reviewed be found not to secure the government and rights of the states against usurpations and abuses on the part of the United States, the final resort within the purview of the Constitution lies in an amendment of the Constitution according to a process applicable by the states. So he was referring to the Convention of States. George Washington: "If in the opinion of the people the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way which the Constitution designates." Thomas Jefferson: "The ultimate arbiter is the people of the Union, assembled by their deputies in convention at the call of Congress or of 2/3 of the states. Let them decide which they mean to give an authority claimed by the two of their organs. And it has been the peculiar wisdom and felicity of our Constitution to have provided this peaceable appeal where that of other nations it is at once to force." So what he's saying here is basically they watched other nations and they had to experience this themselves. They had to go to armed conflict to get their way. They wanted to provide a peaceful resolution for us as a last resort. And I can tell you, This is the last resort that they've provided us. This is the last tool in the Constitution because they knew this day could come. Even Alexander Hamilton, I like to highlight, Alexander Hamilton was one of those who favored a strong national government, as well as Abraham Lincoln. But even he had this to say. He says, by the 5th article of the plan, we may safely rely on the disposition of the state legislatures to erect barriers against the encroachments of the national authority. And he also said, the national ruler, when it comes to actually calling the convention, the national rulers have no option on the subject. The words of Article 5 are peremptory. The Congress shall call a convention, so they don't have a choice, is what he's saying. And finally, Abraham Lincoln, plainly the central idea of secession is the essence of anarchy. The convention mode seems preferable in that it allows amendments to originate with the people themselves instead of only permitting them to take or to reject propositions originated by others. So he was basically saying, we want the people to be able to amend themselves and not be forced to only take or reject an amendment from Congress. So those are some very insightful comments that I found, and I thought they were just fantastic. I got those from some of my colleagues back east, some of the other state directors. And a lot of these guys have been doing a lot of research, so it's just fascinating. So to recap, the third wave of Article 5 writings, the historical writings that we talked about, the most recent body of evidence concluded as follows. A convention of the states is in fact a diplomatic meeting among delegations representing their states. It is truly a convention of the states. It is not a congressional convention. It is a limited purpose gathering, and it is not a constitutional convention. And finally, it was modeled after a long tradition of limited purpose multi-state assemblies that followed established, widely accepted protocols and procedures. Not only can a convention be limited as to the subject, the founders expected it to be so. And then finally, congressional power over the convention process has been consistently limited to counting and classifying the applications, setting the time and place, and determining the mode of ratification. That's it. And then finally, Article 5 questions can and have been adjudicated by the courts. So they can be addressed by the courts as well. Checks on a runaway convention. Very briefly, we have the historical precedent now. We understand much better from the more recent research that has been done on the conventions that led to Article 5. We know what the founders were looking at or looking back to base Article 5 on, and so we know a lot more about it. The scope of the convention call is another one. The scope of the convention call obviously is limited in scope. So it's only common sense to that the scope of the call is all that they can do. So anything outside of that can be legally challenged. The scope of the commissioning documents and the instructions. The commission itself designates a commissioner as a representative, and then the states have, again, the option of levying additional instructions upon their delegates. They can restrict them from only discussing certain things. They can restrict them from voting on certain things. And if they get out of line, they can recall them immediately. And I have some great examples of not all of them are bills that have been passed, but I know some of them are being proposed, and I know Indiana has passed one. They're already starting to pass laws for criminal penalties for any delegates that get out of line at the convention. So I can tell you the states are getting on board. They're starting to get spun up on this, and they're really starting to understand this. I apologize. We'll get to you. I will, I promise. State laws. Again, state laws. I've been researching about 7 of those today, and those cover Texas, Oklahoma, Indiana, Arizona. All of those are proposing certain legislation to clearly define what they expect at such a convention and what their delegates can and cannot do. They're even coming up with an oath of office, and if they violate it, some of them are coming up with felonies and things like that. So trust me, the convention delegates aren't going to want to get out of line. Each state, again, this is a great one. This is based on tradition. Each state will have one vote. Rhode Island's 1 million residents will have the same number of votes as California's 30-something million residents, and I love that. So each state will have one vote. That is the understood tradition. And finally, ratification obviously has to be done by 38 states. So 38 states times 2 legislatures, if they do it by legislature, that's a lot of legislatures that have to pass each and every single amendment. And then so basically that tells you it only takes 13 states to kill any amendment or to stop it. The bottom line, multi-state government conventions were well established, understood, and they were widely accepted by generations of Englishmen and Americans leading up to the Constitutional Convention. The Article 5's language was not drafted on a blank slate. The founders knew exactly what they were looking at. They knew what they were doing because they were basing it on their own experience and previous experience. They didn't just pull this out of a hat. So they knew what they were doing, and they did it with very specific intent. And their words tell us that. Finally, the myths of a runaway convention, quite honestly, they were simply based on historical fallacy. And they didn't base it on any real evidence other than snippets out of the Constitutional Convention. But fortunately, we have a much better historical record now and a better body of evidence to rely on. And finally, ratification of our own Constitution hinged on Article 5. So that should tell us something. So I like to leave off with this one. Let us go on then. Perfecting it by adding, by way of amendment to the Constitution, those powers which time and trial show are still wanting. And that was Thomas Jefferson. So finally, what is a plan? Very quickly, I'll run through our plan. 2 parts. Our application strategy is to rein in the power of the federal government. Basically, there's three subjects, and I'll cover it here very quickly. To limit the size, scope, and jurisdiction of the federal government is it in a nutshell. And there's operative language that we have, and that's on the next slide. And that operative language is what we're using in all 50 states, and we're trying to get it in. So obviously we only need 34, but we're pushing it in all 50 states. What is that operative language that we're looking to use? Propose amendments to 1, impose fiscal restraints on the federal government, 2, limit the power and jurisdiction of the federal government, and 3, limit the terms of office for its officials and members of Congress. So that basically includes the judiciary as well. Oh, good. Yeah. So the next question is, okay, what could be potential amendments? Because we are kind of talking about a broad subject range here. We're not talking about just one amendment. These are some potential amendments that could come up. Some of these are out of Mark Levin's Liberty Amendments, the Liberty Amendments book. Limits on federal spending and taxing. We know that's the Balanced Budget Amendment, but we know that we need it on both limits on spending and taxing. Because if we just pass a balanced budget amendment that Congress might pass, they would just increase taxes. Limiting federal regulatory power. Congress has basically abdicated their powers over to agencies to make laws for them. That should not be. It cannot be. It's illegal. It's unconstitutional. Term limits for Congress, and the one I love most is term limits for the Supreme Court. Limits on the use of executive orders and granting states authority to check Congress. Protection of private property, and protection of free enterprise system. And I think that may have something to do with what Mark Levin has talked about often is, what's it called, the Commerce Clause, and how that's gotten out of control because basically anything with a dollar sign on it, the federal government likes to come in and put its hands on. That's not right. That goes back to terminology. The Commerce Clause, as he discussed at one time, I understood, only pertained to interstate shipping only. That was it. So what we're talking about here is going in and truly redefining and clarifying what the founders meant. So this is what we're talking about. As a wrap-up, momentum is building very quickly. We are organized in all 50 states. We don't have leadership in all 50 states, but we do have volunteers, petition signers, and a presence in social media in all 50 states. 44 of the states, including California, have a leadership team. And we have, actually this is kind of a dated slide. I know we have well over 700 district captains, and I have in the 80 assembly districts that we have in California, I have 37 district captains covering about 27 districts. So I still have my work cut out for me, but we have gone in about, I would say from November or December to now, we've gone from about 15 to 37 district captains. So we've been moving pretty fast. And I'll tell you, in our database alone in California, we have well over 12,000 supporters. And we were at about 7,000 when I came on as a state director back in September. So, I mean, trust me, the momentum is building quickly. There are people that are just coming on board without us even having to ask. States that have passed the resolution, there's 3 states, Georgia, Alaska, and Florida have passed the resolution and are good to go. And I put the entire count here up to 41, and the reason I do that is that we actually have, there's 3 major points here. 3 states have passed it. 30 states so far have since applied or filed their application in the legislature, to include California. 30 more states have filed it for consideration. So that tells you right now we're at 33 as far as the total number of states that are actually considering it. But I can tell you right now, we have 41 states total that have a legislator that are willing and ready to commit to filing it for consideration. And we have already filed it. It's already on the docket for this year. Yeah, that may be a surprise. I apologize, but we had some circumstances. We were actually aiming for 2016 to be able to build our grassroots up, but some circumstances that I can explain later. We went ahead and we found 2 sponsors, and one of them ended up going ahead and filing for us. So anyway, but what this tells you is 3 states have passed. The states that have filed now bring us up to a potential of 33 states that are considering it now. And then we know that we have 41 states with legislators that are willing to sponsor it. So that tells us a lot. We need 31 more states, but we have 41 that are willing to file it and consider it. So it's pretty encouraging for us. It's very encouraging. And it may not happen this year, but and we've got our work cut out for us. There's a lot going on in about 8 states right now, but this tells us a lot. This gives you the big picture that there's a lot of states starting to get on board, and the conversation is spreading fast. Finally, I want to cover, and this is not out of disrespect because I, quite frankly, didn't have anything against them, but I got to bring out a couple of key things that we have been getting some extremely strong opposition by the John Birch Society, by Eagle Forum, and a couple of other groups. But to be quite frank, they have tried to associate us with George Soros. They have tried to label us as a constitutional convention, a con, that there's no way that we can control what's going to happen. They have basically used every tactic that they possibly can to fearmonger state legislators throughout the country. And so they have caused some problems in some of the states, but what we are doing is exactly this, and we're trying to educate the legislators on exactly what the history of Article 5 was, what the founders said, and what the reality is. And because really, when it boils down to it, our state legislatures have as much of a stake in this as we do. It's the states that are losing their power. I mean, we need our state legislators to stand up because they're losing their power. They're becoming regional powers of the federal government is all they're becoming. And so they should take this seriously. So I hate to say it, but they have forced us into this because of what they've done. But I'll be honest, what we're doing is basically coming out with facts. We're not going to come out with anything but facts. And 2 of those facts are, 1, the John Birch Society is saying that this would be nothing but a con, and they oppose any kind of convention whatsoever. And the bottom line is their founder and their second president both supported the liberty, different forms of a liberty amendment in the past. And the second individual, Mr. Larry McDonald, even mentioned and supported an Article 5 style convention. So what we're having to do is basically come out with a few facts here because they're coming against us saying that, you know, we're associated with George Soros, we're being funded by George Soros, we're doing his bidding, and quite frankly, it's really disheartening, but some of the supposedly most conservative group out there is coming against it and saying it can't be done. And some of the arguments that they actually make are the Constitution was not legitimately ratified, that it was not legitimately passed. And so our question to folks that come out with arguments like that from the John Birch Society is that if you truly believe in the Constitution and are a constitutionalist and you believe in the Founding Fathers and what they did and what they said, then how can you possibly make such a hypocritical argument that the Constitution was not legitimately passed? It just doesn't make sense. And so unfortunately, we're having to come out and basically take the gloves off in a limited way and highlight some facts here. So they were once for an Article 5 convention in the past, but now for some reason they are not. And this recent news article came out from the Washington Examiner recently highlighting that some documentation, I have a copy of the memo, that basically highlighted that a Soros-funded organization called the Montana Budget and Policy Center recently came out and was urging state legislators to basically utilize the John Birch Society arguments to oppose any kind of Article 5 convention. So that right there told us all we needed to know. So I'm just bringing that up. It's disheartening to have to, but it's something that we need to bring out because, you know, we're not funded by George Soros, because I can tell you, I probably wouldn't be a volunteer only. It'd probably be a paid staff. So I'm a volunteer doing this. I'm doing this on my own dime, and all of us are volunteers doing this because we believe in our country, we believe in the Constitution, and we want this to happen. I took an oath for 25 years to the Constitution. I'm not about to let Washington do what it's doing. So with that said, please, I apologize for taking so long, and I don't know how long that was. I hope that was helpful, and I appreciate it. And I want to take as many questions as I possibly can. Gentlemen, I apologize. I know you've been raising your hand forever.
Video services provided by Vacaville's very own Choker Films. Video production, editing, and compositing services.